The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
One.
Welcome back to Condo Craze and HOAs here on our YouTube channel. I'm Karen Curtis. This is attorney Eric Glazer. He's the one that you're going to ask any questions about your condo or HOA that makes you crazy from one week to the next. He is the man to ask because he's board certified in community association law. He's an attorney here in Fort Lauderdale, and you have an office also in Orlando.
Yes, we do.
And you have been doing this for a long time. You've even invented classes to teach people, the board members, what they need to know, and that's now going to become, it's on the governor's desk, the law.
Talk about it finally.
Oh
For
my
the
gosh.
HOAs, it's on the governor's desk as we speak.
Oh my God. Okay, so the number to call is...
No, I stand corrected.
No,
It's signed for HOAs.
Yeah, I was going to say. I
and
didn't
we'll
want to
talk
correct
about what happened this past week for
Okay.
condos, right?
Okay,
Exactly.
so 717-GLAZER-8. Again, that's 717-GLAZER with a Z8. Numerically, it is 717-452-9378.
Yes, there's just so much to talk about. I'm jumping ahead of myself, but this is going to be a busy opening here. And but before we get there, like we say every week, don't forget to subscribe to two different things. Of course, number one is the Condo Craze and HOAs channel on YouTube. You can watch the show live. You can ask questions, of course, live in the chat box. Or if you miss a live show, we've built up an incredible library. We're literally getting like thousands of hits now when the show is over.
Wow.
People are going through our library. It's really... very proud that we built that up, guys. Really.
And the blog that you have, too. I
Yeah,
mean, you have,
exactly.
you're such a wonderful resource.
But yes, I appreciate that, and that's what
You're a national treasure.
That's really what they appreciate.
Over 10,000 subscribers to that
That's
blog.
yeah.
To your
fantastic,
blog?
Fantastic.
Oh my God.
Yeah, really great. And join the Condo Craze and HOAs email list, and you can do that by going to condocrazeandhoas.com. By joining each week, you can get emails about the show, our blog, our seminars, like you say, Karen, our newsletters, updates on the law, and a lot more. Talk about updates on the law. There's just so much to talk about. Again,
Oh my
this
God.
morning, it's wild.
Well, and don't forget, you can also follow the show on Facebook, TikTok, and Spotify, or wherever you get your podcast.
Absolutely. All right, we do a blog every morning also at hoa-condoblog.com. Again, hoa-condoblog.com. Tomorrow's topic, pretty important. Can the as amended from time to time problem be fixed? And make no
We talked
mistake,
about that.
it is a problem. It's a problem. It's creating confusion everywhere. It really is.
Yeah.
All right, some big news to start. And we kind of got ahead of ourselves here. The Powerhouse Condo Bill 1021, guess what? It's been delivered to the governor.
Woohoo!
Simply awaiting the governor's signature at
But
this
it's
point.
been there before.
Karen,
It's been on the governor's desk
right?
before.
Can you imagine after working on this for so many years?
I
for
know, it's been.
mandatory education. But let's see what happens this coming week. Could be a very, very big story to report. And as we reported last week, the blockbuster HOA bill, which is 1203, that has been signed by the governor. That's now law. And today we're going to talk about lots of other community association bills that have been signed now. They're done, signed by Governor DeSantis, and they're now
Okay.
law as well. Just
And you
a
teach
lot.
all this.
We will,
Yeah.
absolutely. All these new laws we're going to teach as well.
And you also, I heard, interviewed a lawmaker
Yes, we did.
while
Yeah.
I wasn't here.
No, this was during the week on Thursday, and I interviewed the
And she
lawmaker.
drafted the bill?
Who drafted the bill, correct. Early this week, I had the honor and privilege of interviewing Representative Vicky Lopez on why she thought it was time for a blockbuster condo and HOA bill. And that interview is going to air next Sunday, next week. So don't forget to tune in next week to watch. But Karen, you won't believe this. Like you said, we don't want to get jinxed. We want to make sure that this goes through, no problem.
I think it'll be fine.
And for over a decade, we're trying to get this done. We want to report on this show that a mandatory education bill was finally signed and it wasn't vetoed. Well, guess what? Based upon my calculations, next week's show, can't make this up, next week's show is number 666.
No.
Yes.
No.
You can't make it up. It's my 666th show of all the numbers to pop up. I didn't need that. I didn't need that. Any other number?
Maybe you shouldn't even put a show on that.
Yeah, I don't know.
Just skip that
We're
week.
gonna risk it and we'll go with it. But just let you know, we can't make this up.
And that's going to be when he signs it.
Exactly. Yeah, correct. But the number 666
666.
though is to report that it's been signed. Anyway.
Oh my God, just go past it, make it 667.
Yeah, it's like
You
not
don't
having
have
the
to do it.
13th floor in a hotel.
That's right.
Okay.
Yeah, just
Let's
surpass
see what
it.
happens. All right, before we
That's
get started,
hilarious.
I just want to say some good things about one of our longtime sponsors, and that's PD Painting. And in my home last week, I had an obvious water leak in the wall in my master bedroom. Yeah, it was a big problem. And it looked like the wall was suddenly like bulging out.
Oh God.
And I called PD Painting and I asked Daniel if he could send somebody over. He sends over a crew and they find the leak, they make the repair, put up a new wall,
So
looks like new, fantastic.
They repaired a leak as well
Right,
as
they're not just painting, right? We'll get to some other things that they did. Then I say, hey, I got a pool leak. And I was told that the pool needs
Grouting?
grouting. Do you guys do grouting of a pool? Says to me, no problem.
Oh
The
my
crew
gosh.
regrouts the tiles, no more leak. Okay? Then I ask if his guys can put down pavers, right, in the backyard in a small place. They start to put it down. It looks so great. And I tell the guys, can you keep going? Can you keep going? And then all of a sudden, one side of the house is completely, repaved. So in one trip, they fixed the leak in the wall.
Oh my God.
They fixed the pool leak and they put down pavers on one side of the wall. And I think some pictures are going up of the great work that they did. So great job, Daniel and PD
They
Painting.
need to
Really
change their
so
name.
appreciated. Really, you guys did a great job. And they can do it for you too, believe me. Really,
PD
really.
Painting,
Thumbs
painting,
up
and
to
plumbing.
PD Painting. Yeah, right. What don't they do? So
Yeah,
great job,
PD
guys. Much appreciated.
Tripled.
Yeah. All right.
Oh my
Back
God.
to the news.
Yeah.
All right. There were a few other condo and HOA bills that passed, but these bills, weren't the ones that got most of the attention. But make no mistake, they're very important and they deserve attention. And here we go. Okay. House Bill 59 passed. It became law. And here's what it requires. It requires that before October 1st, 2024, coming up, right? An association shall provide a physical or digital copy of the association's rules and covenants to every member of the association and going forward to every new member of the association. So somebody moves in,
Yeah,
you get a copy of the
you
rules.
should.
Makes sense, right?
This is
Also,
an HOA.
This is any association.
Oh, okay.
Any association. So again, good question. Condo and,
And
HOA.
HOA, okay.
Any association. And if association's rules or covenants are amended, the association has to provide every member of the association with an updated copy of the amended rules or covenants. So everybody should know. They shouldn't have to guess what the rules are. I think this is a great bill. I really
So
do.
what happens if the association has a website?
Right.
So
You'd
can
like
they
to
just
ask
put
that
the rules
question?
there?
It's a great question. Yes. And the short answer to that question is yes, put them up on a website, making it all the more reason, again, have a website.
Yeah.
Right? I don't care. Now it's 25 units for a condo, but this is something that should have been in place for a while.
It's a win-win for everyone.
100%. Have your website taken care of course.
And I understand that the new law became effective regarding hurricane protection.
Yeah, this is important as well. Got to concentrate here. House Bill 293 was signed by Governor DeSantis, and it too applies to all homeowner associations in the state. And here's what it says, okay? The board or architectural review committee must adopt hurricane protection specifications. Again, hurricane protection specifications for each home governed by the association. And the specifications may include the color and style of the hurricane protection products and any other factor deemed relevant by the board. All specifications adopted by the board have to comply with the building code, of course, right?
So what does this law mean when it says hurricane protection?
Right. They got to adopt hurricane protection specifications. So what is hurricane protection? Okay, the statute goes on to give a definition of that. The term hurricane protection includes, but is not limited to, Roof systems recognized by the Florida Building Code,
Okay.
which meets ASCE 72 standards. So that includes metal roofs. Okay. So now,
Cool.
when you see it, metal roofs are allowed. Permanent fixed storm shutters, roll down track storm shutters, impact resistant windows and doors, polycarbonate panels, reinforced garage doors, erosion controls, exterior fixed generators, fuel storage tank, and other hurricane protection products used to preserve and protect the structures or improvements on a parcel governed by the association. So everything that I just mentioned, bottom line, all of that's allowed.
Okay,
Okay.
and
But the association can adopt standards regarding it. Okay.
and so it seems like the statute is saying, as long as I conform to your style or color scheme, you can't stop me from putting in the type of roof or windows.
That's the way I see
And
it.
shutters that I
Exactly.
want?
Yeah, I gotta comply with your color stuff.
So I don't
but
even-
I'm allowed all of those things.
I don't even have to do shutters. I can do impact windows.
Right,
which
correct.
would be better.
Correct. You can do those things, but if there's a certain style, that's
Okay.
a certain color, right? Okay, you got to conform to the color. You know, you can't be the only black roof in the community. I can understand, you know, adopting reasonable color schemes, but those types of roofs,
That's good.
all allowed. Okay, bottom line.
And
yeah.
any
yeah.
other laws passed
Any others laws passed?
that
Yes.
we should know about?
Okay, House Bill, there's so much, like I said, a lot to talk about this morning. House Bill 1029, and this one has gotten a lot of attention. It's now known as My Safe Florida
Okay.
Condominium Pilot Program.
Oh, God.
Okay? And this program, like I said, got a lot of attention, and it's all about a new state program that has not yet been funded by the state legislature. Keep that in mind, not yet funded. But if it's eventually funded, here's how it would work. And I'm oversimplifying things a little bit here, because we could talk about it for an hour. But generally, here's what this new law is about. It would pay inspectors to inspect a condominium and prepare reports detailing what improvements in that property the association can make in order to mitigate hurricane damage and the estimated reduction in the association's insurance premium. So they'd send out inspectors, okay, when they inspect, what would this do in terms of hurricane safety and how would it reduce that association's insurance premium? The association would then take this mitigation report and they would apply to the state for a grant of money to make repairs. Okay, they got this report.
Nice.
They send it to the state. They want a grant of money. And if approved, for every dollar the association contributes towards the repairs, the state will contribute $2.
Oh my gosh.
Okay, so 1 to 2 ratio, up to a maximum of $175,000 per association. It sounds fantastic.
But did they fund it yet?
Yeah, that's the question of the day. And the question is no.
So,
This has not yet been funded.
and then, you know, we're always talking about the DBPR
Right.
condos. They
Yes.
each unit sends $4,
Right.
and that money just rolls over.
Okay,
You can't
great
use that
question.
money?
Great question.
Because that money's
That's
like
not
sitting
money we're talking about.
there. Okay.
You'll see in the interview next week when I interviewed Representative Vicky Lopez, that money is going now to the DBPR because, again, as you'll see next week, the jurisdiction of the DBPR to investigate things has gone crazy.
Okay.
Everybody's
So-
complaining over the last 2 decades. Every time I file a complaint with the DBPR, they tell me we don't have
gonna use
jurisdiction.
the money.
Well, guess what? They do have jurisdiction now. They're going to be expanding their staff tremendously,
Okay.
and they're finally going to use all that money. So that's money is not going to be used to fund this new program. It's going to come from a different source. So that's why the legislature has to come up with money to fund this program, and it has not been funded yet. This $175,000 per condo.
I think they should because of a number of reasons, but mostly because half the state lives in a community association, and
Yeah.
they're already spending a lot of money that they don't
100%.
have because of now all of these
Absolutely.
new things, and they need help.
It's a good thing for
It's
some
good for everyone.
associations. $175,000 is going to
It's a
be
lot.
Yeah, for some, yes, it's
Yeah.
going to be a lot. For others, it's going to be a mere pittance.
Yeah.
Some associations, I met with one this week, we're talking about 12 to 15 million that they're going to need to fix the place up. Others are facing 20, 30 million dollars.
Well, maybe you could tell the legislature to kind of make it, work
Proportionate.
with the size.
Yeah,
Proportionate.
I think that would
That's
be a
the word
good
I'm looking
idea. It should be proportionate to the
Yes.
size and the amount of your loss.
Yes.
So I agree with you. That's the way to go. All right, let's do this. We spoke about a lot of things this morning. Tell us what you think. Give us a call right here on the show, 717-GLAZER-8. Again, 717-GLAZER-8. That's 717-452-9378. Or drop us a question or drop us a comment in the chat box on YouTube. We'll be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
For mitigation after a catastrophic event, building restoration, repair and remediation consulting, or Senate Bill 4D inspections, please visit rimkiss.com.
Welcome back to Condo Craze and HOAs. I'm Karen Curtis. This is attorney Eric Glazer. We've been doing this for almost 15 years.
15 years.
Yeah.
A lot of fun in that 15
A lot of
years.
fun. And we're taking your calls. And also, we're taking questions in the chat box on our
Lots of good
YouTube channel. Just to
Yeah.
give out the phone number again, it is 717-452-9378 or 717-GLAZER with a Z8.
Love the comments. The only one I'm worried about. Donna Palante writes in and says, good morning. Is the show on yet? I'm not seeing here anything. Last night was Friday, right?
Yeah.
I'm guessing Donna got to sober up and come join us.
Oh,
Come on,
Donna.
Donna. Wake up. Come join us. Absolutely. We're waiting for you. Okay. Abby writes in, please explain the new HOA parking laws. Can a homeowner park in the street when it's not allowed because of narrow streets? Can a homeowner park in guest spot meant for all owners? No, that's not what the new law is saying. The new law is basically saying if you got a vehicle that's your work vehicle,
Okay.
right? They can't say you can't park in your own spot.
With a sign
Come on,
on
it's
it.
your home, because it has some writing on it, whatever. That's your vehicle that you use to make a living.
That was crazy. What did people do with those?
And you'll see the concept of the new HOA laws that have passed, a lot of it was meant to say, hey, get out of my life. You know, I know you could have your fingers in a lot of things, your hands in a lot of things, but it gets to a point, see Representative Lopez say this.
Okay.
It gets to a point where you're just too involved in my
Yeah.
life. I can't park my car
Violation.
at my house. Come on, right, exactly. We spoke about that, Karen.
See, you
We spoke
met
about the
Cynthia.
State Farm commercial. Right. So basically that's what it's meant to be. Now, it doesn't mean that you get the right to park in the streets
Okay.
and violate code, for example.
Right.
No, that's not what it means at
In front
all.
of a fire hydrant.
Right, or fire hydrant, or preventing an ambulance from going down the street. Doesn't mean that at all. But it basically means I could park in my driveway at my home.
And the governor signed that.
Governor signed it.
It
It's
goes
the
into
law.
law July 1st?
Correct.
Okay,
Correct.
there you go.
So, you know, we're
So
just
if you-
about there. Helene writes in, my condo association used reserve funds to pay a little litigation settlement.
Oops.
Absolutely 100% wrong.
Oh, boy.
Cannot do this. Now, it used to be you can take reserve funds and you get a majority, and the reserve funds were used for a certain purpose, set aside for a certain purpose. It used to be you could change that purpose by getting a quorum together and a majority of a quorum. It's not like that anymore, okay? Brand new law. In order to change it, it's a little harder. Now you need a majority of all of the units, okay? So it used to be very easy. Let's say you're in an HOA and you have 100 homes. A quorum is 30. You can get 30 people show up, 16 vote to use the reserve funds for something else. It's done. Can't do that anymore. Now it's a majority of 100, it's 51.
Okay.
So a lot harder to use reserve funds for something other than for which they were originally intended.
Like paying for attorney's fees or whatever they paid for.
I like that, but no. It's paying for big repairs to the property.
Okay.
That's typically what it's set aside for: roads, building repairs, construction repairs.
But
okay?
her question was, they use reserve.
I'm sorry, they used it for a settlement.
A settlement,
Absolutely can't
okay.
do that.
No.
Cannot use it for a
But if
settlement.
they vote for it,
If
51,
they vote for it,
then
fine.
they can.
Yeah,
Okay.
no problem.
You just
Get
can't
that vote.
willy-nilly use the reserve funds.
100% illegal under 718 or 720.
Whoops.
Okay? Rob, let's take our first call.
All right, let's see. Let's go to Mary Hanson.
Oh.
Good morning, Mary. Where are you calling from? Mary, you there?
She seems quite contrary.
5, 4, 3.
Yes, I'm here.
Oh,
Yes,
Mary.
okay. Good morning, Mary.
Good morning.
Where are you calling from, Mary?
I'm from Clearwater Beach,
Clearwater.
Florida.
Okay. Good morning. How can we help?
I have sent registered letters to both the association and the property management with signature return receipt requesting financials such as bank statements, digital checks, operating accounts, reserves, etc., etc. Years I have been denied access to any of this information.
Okay.
We finally now have a website since we got our new management firm, and they were one of the management firms that denied it as well. In the website for financials, they're only putting one year in financials. And in other words, December 31st, 2023, and it states clearly owner's copy. I know this is a violation, and I was just wondering what recourse I can take, because the word is suspecting that monies are being funneled back to
Okay,
the property
Mary, let me cut you
manager,
off for a second.
the president,
All
etc.
right, Mary, let me cut you off. Are you in a condo or an HOA?
Condo.
Okay, so what I would do if I were you, you have a new management company, right? So I would go to that
Yes,
management
but
company. Do they maintain an
They'll be
office?
like
Do they maintain an office where you live?
yes, they do maintain an office.
Okay.
The manager here is reluctant.
Okay,
I have
hold on,
taken
hold
this
on,
all the
Mary.
way up
Mary,
to-
Mary, let me ask some
Go ahead.
questions here. If they maintain an
Okay,
office,
sorry.
what I would tell you to do is walk into the office, okay? Walk into the office and say, while I appreciate the records that are on the website, you're required to maintain 7 years. You know, you certainly are required to maintain what I asked you for. So again, I'm here today, I'm requesting access, okay, to those records. They're not up on the website. Do you have it today, or is there a day I can come back?
Okay.
Okay, and then document what you did. Document it. And then if they don't give you access, you have a right to send another letter, send one more letter to the association saying, you didn't respond, you didn't give me access the first time. I'm asking you again to provide me the records within 7 days. If you don't, and this is important, you have to say this, if you don't, I will be filing an arbitration action against the association.
Oof.
So you're going to walk in, you're going to ask to see the records. That's one time. You're going to send a letter to the association saying I want access within 7 days, and if you're not going to give me access, I'm filing an arbitration action. So let's say you don't get access to those records. So now you have a first letter. Now you have a time that you walked in and asked for access to the records. You have another letter that shows you gave them another chance within 7 days. And now it's time to go to arbitration. And
Which you will win.
And when you go to arbitration, if you win, you get your attorney's fees and court costs back as well. So that's the way to handle that situation. Next call, Robert.
Let's see. Let's go to Christopher.
Good morning, Christopher.
Hi there, do you hear me?
Hey, Chris, how are you? Where are you calling from?
Around I'm in Ohio right now, but the condo I'm calling about is around Sarasota.
Great, fantastic. Hey, how is Ohio going to go in the presidential election? What's your thoughts?
It went for Trump by over 6 points last time, so I don't think there's any risk that it will vote any contrary to that.
Okay, you heard it from Chris. How can I help you?
So I called you once before on an association where there's been a lot of issues, and we just had an election overturned due to compromised electronic voting. But here's something else that happened. It was heavily affected by Ian. I just want to get your reaction to this.
Yes.
Heavily affected by Ian. Got a significant insurance settlement, and kind of in a skunkworks project without ever there being a board vote, out of not the insurance settlement directly, but out of the special assessment fund that was for the deductible for the insurance.
Right.
A few people, including the board president, dispersed over $400,000 to individual unit owners.
Okay.
Again, ostensibly for reimbursing them for different things related to the hurricane.
Right.
There was never any board vote. There were some discussions of the concept of having such a thing in a board meeting. I've read the statutes, and I know there's statutes that talk about, a unit owner needing prior written consent, having to have made a request prior to the universal settlement of the claim. But have you run into that kind of situation? And what's your kind of reaction to? I think a lot of people are stunned that it was never voted on.
I agree for that. But why would the association itself, right, distribute funds to the owner? Is this a condo or HOA?
Condo.
A condo. Okay. So why would the association distribute funds to an owner itself? The only thing that the condo is responsible for in that regard, right, is replacement of the common elements, right? That's it. They don't have to pay you back to make repairs to your unit, right? So why isn't the condo getting a contract with one contractor to repair the common elements, including the walls in that unit? Is the building being rebuilt?
So that's no, but just let me clarify.
Yeah.
Kind of what happened was there was a contractor for rebuilding the common elements.
Right.
But unit owners just went ahead and did things because they wanted to move back in. So, for example, they did all the drywall on their unit on their own.
Right.
Oh.
They did not have any prior written consent.
Right. I understand.
And
yeah.
Frankly, even on the disbursements, it's just stunning to me.
Yeah.
Even on the disbursements, it appears they were not required to give receipts or anything like this, but they just dispersed based on the insurance adjuster report. If the insurance adjuster report said your unit was, $3,000, here's $3,000. Have a good day.
Insanity. Now you have a problem because you also don't know if these unit owners got any required permits that are necessary. You don't know if electricity went back the wrong way and it can now burn down the entire building. You don't know. So if unit owners put back, and now you don't even know if the price is right. You don't know respectfully if that unit owner is trying to gouge you.
Well, you don't even know if they had someone who was certified doing the work.
Right. It should have been only done by the condo association.
Yeah.
So it's really tough how you go solve this problem now. Just
to make a quick comment, there's, and I don't, even though you're a lawyer, but this is a question out of thin air. There is part of the statute that says that an association can allow an owner to do rebuild, but it requires, you hit one of them, that the owner has all legal and proper permits and that they have prior written consent of the association to do work on a common element.
Right, but they have
And,
neither.
and that seems to be specific to after like a hurricane or some big calamity.
Right. So I've been
But none
this-
of these people,
yeah.
as far as I could tell, had any prior written consent,
Right.
like a cookie jar. That
Right.
After the fact, we're going to disperse money to our friends.
Right. So I've been through this, many times. Here we are living in Florida, and here we go with the hurricane season. By the way, I don't know if you've seen the literature on this or the news reports about this. They are predicting more hurricanes this year than ever before, right? And they predict, you don't know if this is accurate, but they predict that the storms are going to hit the east coast of Florida.
Gosh.
Yeah, and when I moved to Florida, I remember the Carolinas got it every year after
Well,
year,
La
and then
Niña
Texas
and
and
El Niño.
Louisiana,
Yeah.
and then the west coast of Florida. It kind of goes like in patterns. You
Well,
know?
there's a Bermuda high that
Right.
was steering all the storms away from us. That's
Right.
probably
They
changed
say
by
that
La
that's
Nina
gone.
because the shearing
Right.
wind is gone.
Right.
So now, and the ocean
let's
is
see.
really hot.
Right. You had in June, you had all these
Atlantic.
temperatures, right? Okay, but let's see. You never know, right?
Now that we're thoroughly terrified,
Right,
thank you.
exactly. What I would tell you is if I'm the association, I'm not dispersing not a dime until I see a permit and I see a closed permit from the county or the municipality where where the property is located.
Well, how do you put the
Something
horse back in
signed
the barn?
off by the building official. If not, I'm not dispersing anything. And by the way, it would be negligence, absolute 100% negligence on the part of the association to approve a repair, right, that has not been approved by the local building official, that doesn't have a permit that's signed off on. Again, can you imagine you allow this person, this unit owner, to make repairs to the building, including electrical repairs, including structural
No,
repairs.
I can't.
Right?
Well,
Structural
how do they
repairs.
undo everything because they did
Right.
that?
But imagine later on, there's a collapse of portion of the building because you didn't require
You're
a permit.
personally.
So again, if I'm on that board, I'm going to want to see the people I already paid for. Sorry, we're going to take that money back. We're going to
Okay.
sue you for it. We made a mistake, unless you get that permit closed.
Claw
Okay,
back.
there's no other way to do it at this point because you have to make
Can I ask
sure
you
you
one
didn't make the
quick-
building unsafe. Yeah, we got to take our bottom break of the hour, so really quick.
Can you get a permit after the fact?
Yeah, you can.
So
yeah.
the records part, I'm sorry. So there's been a question on the records part of it is,
Yeah.
because owners are starting to want to see the records of who got what money
course.
out of this.
Yes.
And there's actually board members saying, well, maybe those records are confidential and,
They're not-
and owners can't see them.
Absolutely 100% not confidential. Again, what does the Records Act say? Other unit owners are entitled to see basically any records that have to do with the operation of the association. And I can tell you that arbitrators have defined the term operation of the association very, very broadly, and it certainly requires unit owners having the right to see payments that went to other unit owners to make repairs to the building.
Good.
Certainly repairs to the building are considered operation of the association. So you can see all of them, no doubt about it. Got to take our bottom break of the hour. Keep the calls coming in, 717-452-9378, 717-452-9378, or post on the board. We'll be back right after this.
Is your condominium or HOA in need of accounting services? Look no further. Gerstle, Rosen & Goldenberg is one of South Florida's largest accounting and auditing firms, as recognized by the South Florida Business Journal, and is one of the few accounting firms uniquely specialized to provide accounting services to their growing condominium and homeowner association clientele throughout Florida. With primary offices in Aventura and Boca Raton, satellite offices in Naples and Orlando, and a professional staff of 65, Gerstle, Rosen & Goldenberg is prepared to meet the needs of any condominium or HOA in the state. The professionals at Gerstle, Rosen & Goldenberg also have experience working with timeshares, cooperatives, hotel condominiums, mixed-use buildings, and ancillary operations like restaurants, spas, and country clubs. Put their 25 years experience in your corner. Gerstle, Rosen & Goldenberg, 305-937-0116. That's 305-937-0116 or grgcpa.com. condominium.
Someday, you will need insurance. And for that day, you'll be glad you wrote down Insurco Insurance and Financial Services. Why? Because Insurco virtually insures everything. They're a full-line insurance agency that'll put together the best possible coverage and premium for almost anything. Need homeowners or condo insurance? Call Insurco. Need auto or motorcycle insurance? Call Insurco. How about golf cart insurance or trailer and RV insurance? Just call Insurco for a free quote. They're open every day. From renters insurance, officers and directors insurance, and personal liability umbrellas to all types of business insurance, boat insurance, cancer policies, life, health, and annuities. All you need is Insurco. Get a free quote. They service Dade, Broward, and Palm Beach. Speak English and Spanish. Insurco Insurance and Financial Services. It's the only name you need. Office at 14401 West Sunrise Boulevard in Sunrise, inside Edmore Chevrolet.
Call 954-846-1206. 954-846-1206. That's 954-846-1206.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
So welcome back to our second half of Condo Craze and HOAs here on our YouTube channel. Karen Curtis, attorney Eric Glazer. He specializes in community association law. The phones are stacked. We have a lot of questions on the chat board
as a
here.
matter of fact, Kathy, thank you. You wrote in, wow, 198 people listening, Eric, you're achieving stardom status. Thank you, but we're actually above that. What did we hit today, Rob?
In views, I think we hit 222 at one point.
I saw 228. I wrote it down.
228. Okay,
Yep.
guys, what can I say? Those of you at home, thank you so much. We are truly honored. Okay, let's see what next question. Captain Cook writes in, can you explain what happens if the board quits over the mandatory education?
Oh!
I cannot find board members as it is. Now they are making them take classes. I may not have a quorum anymore. This also came up. Watch the interview next week of Representative Lopez, because I honed in on that potential question. You know, it's difficult to get people to volunteer. Now what happens if you're going to make them take education courses? And here's the way we both feel about it. If they don't want to sit for an education course a few hours a year, good. I don't want that person on the board. That's the last person you want on the board. People that think they know everything, they are dangerous for your building, right? Really dangerous. They can cause significant problems for your building if they're not interested in taking a 4-hour course, especially.
It's free.
Especially, yeah, but especially after the new laws that have passed after Champlain Towers. I mean, do I have to tell you how important those new laws are to learn and complicated they are to learn? Right?
But
so they don't want to take the 4-hour course. Good. Goodbye.
It's these people who've been on the board for a long time that think they know what's going on, and they know the least.
It's double-edged sword. I thank them for putting in their time. I really do. It's a thankless job. But if there ever was a time to now go back and learn something, look, that's the way it is. Gerald writes in, loves your show. When will we be teaching these new classes? I'm being asked that all the time. September is when it all starts over again. So relax, take a break in the summer, right?
Well, and the ones you just taught go toward
yes, correct.
The new law.
Yes, but September, man,
New
are we going to
stuff.
get people? You see how people are, listening into the show? The amount of traffic, the amount of people showing up for the education classes, it's going to be wild. So that's why I'm asked, I don't know if we want to take this course with hundreds of other people, and it's during the day, and we got to take off of work. So if you're interested in having it taught for your association in private, let me know, okay? Call the office. Go back to the phones.
All right, let's go to next caller is Don.
Good morning, Don. Where are you calling from?
Thank you for taking my call. I appreciate it. I was previously on an HOA board, and we contracted with a reputable landscaping company that was opened in 1937 to complete
Wow.
a $10,000 upgrade to our front gate entrance in January. And at the centerpiece of this was a foxtail triple palm. Everybody liked it. What happened was the new board comes in. I didn't run. This was in March. And immediately they state that this is going to overgrow the area and it has to be relocated. It's going to cost about $250. I asked the board president, I said, why not go back to the company that we used and ask them if they will relocate it at no charge if, in fact, it was a bad selection. The president said he'd stop by. I didn't hear anything back. I stopped by the landscaping company, actually met with the owner of the company, who said no, they wouldn't move it, and gave me an elaborate explanation as to how this is going to be a statement piece. It's going to grow up. There's no issues with the roots. And basically he offered to send me an email. Got the email. I forwarded it on to the board, and I basically encouraged them to go ahead, and I clearly believed all the homeowners should be able to see this. And I stated that I didn't want to, but would go to door if necessary. I got a response back from the vice president who said he had emailed the owner. Week goes by, I don't hear anything. I sent an email out. The vice president of the board states that he hadn't heard anything, and he goes on to try to discredit the owner of the company who had only owned it for 2 years.
Right.
Anyways, they go on to move the tree. Okay, they moved the palm, okay, without consideration of homeowners, and actually put it in an area with actually benefits 2 out of the 3 board members. I assembled a cover letter, okay, and I put in an emphasizing that the board should have obtained a third-party professional opinion here, okay, to verify their claims that it was going to overgrow the area.
We got to get to the end of the story quick.
Okay, I ended up delivering this to everyone. Our covenants basically state that the board states that the maintain, repair, replacement, operation, and management of the subdivision, whatever the same, is required to be done and accomplished by the association for the benefit of the members. So my question is, number one, do they have the right not to distribute the email, okay, which contradicts? And secondly, basically, do they can they actually put in a lesser plant? They put in a hibiscus and replace
Rob,
instead of the.
Okay, we gotta cut you off. There's just too much here. We're going to be talking about these freaking plants for 2 hours the way we're going, and I think it all comes down to a $200 plant, right?
Yeah.
Okay.
Material alteration.
Well, a tree,
no,
you can't take a tree down.
Here's the bottom line when we get to all that. There's 2 questions. One was about an email. An email is considered writing now by the DBPR. It's a communication between a board member and an owner. 100% that email is considered an official record of the association. So anybody can see that, okay? Now, next, he had a problem with the tree being moved from one part of an area to another part of an area. I will tell you that when it comes to landscaping, right, the arbitration cases say the board of directors basically has wide discretion when it comes to landscaping. Whatever is in their business judgment, right, when it comes to landscaping, that's in their business judgment. They can do it.
But,
okay?
so it wouldn't be, they were removing a tree that's been there for 100 years. That's a problem. It's a tree they put in.
Might it be a material alteration? I'm sorry?
I think he said it was a pond.
I thought it was a tree that we were talking
He said
about.
a palm.
Oh, a palm tree, a palm tree.
That's the correct pronunciation of palm. Is palm.
Not from New York. So moving a palm tree, would it be considered, from one place to another?
Yeah.
Would it be considered a material alteration? I'm still going to go with no.
I think they put it in, though. And so if they put it in, they can move it.
It's landscaping.
Okay.
That's the bottom line. Whatever we're talking about is landscaping. So the bottom line is, again, the arbitration cases say when it comes to landscaping, the board has wide discretion. It's in their business judgment. A court or an arbitrator has no business interfering with that under what's called the Florida business judgment.
So you can move a palm and put in a hibiscus. Knock
Business
yourself
judgment,
out.
Business judgment. After all of that. Now we spent a freaking half hour on one tree. Back to the phones.
All right, let's go to Julia.
Julia, how are you?
Hello, good morning. How are you?
Good morning. Where are you calling from,
Orlando.
Orlando. How could we help?
So we did a no back in parking policy for our homeowners association.
Right.
And we have one homeowner who did not turn his vehicle around, and he has put locks on it. So we have tried to have the tow company come, but they do not want to move it because they said they might damage the vehicle.
Right.
So we did reach out to the attorney that the HOA has, and they said they can file a pre-suit mediation.
Is it an HOA?
It is an HOA.
Okay, so that attorney, it would be correct. It's time to ask that owner to go to a pre-suit mediation, and that's required under Florida Statute 720. So just to tell everybody how it works, I'm just going to tell everybody how it works. You send a letter to the owner saying, hey, here's what we have a problem with, and you list 5 mediators and what their rates are. You have to choose one of them, and we have to go to mediation.
So does he drive in every day and lock it, or is it just sitting there?
No, it's been parked there. The last time the vehicle was moved was Easter Sunday of this year. He is not, and he is not. He's not the homeowner. He is the boyfriend of the homeowner.
Okay. All right. So I would agree that it's probably the right idea to start out in mediation. Okay. If mediation fails, all bets are off. Go do what you got to do.
But he's the boyfriend of the homeowner.
It's that home that's creating the problem. So I still think that that problem from that home would probably have to go to pre-suit mediation. You lose nothing by starting out there anyway. It's safe. If they don't show up, that's possible to happen. If they don't show up, their penalty is if they win in any subsequent proceedings, they would normally get attorney's fees against the association. Now they don't. Oh. So that's a pretty big penalty, right? Takes the risk away from suing them in the next action.
Why do
they 20 days to respond?
Correct. That's exactly right. They have to pick one of those mediators.
And find the girlfriend. They'll break up.
Right. Exactly. That might be one way to go. Sometimes there's a practical way to go. Good way to go, Karen. Seems like you've broken up a lot over them. It's a joke, Karen.
I know. No, that's true.
All right. Thanks for the call. Who else we got, Rob? Then we got to take our final break really quick.
Let's go to Sydney.
Sydney. How are you, Sydney? Sydney, 5, 4, 3, 2, 1. You there, Sydney? He's not there. Let's take our final break of the hour really fast.
Idea.
Taking your calls. 717-452-9378. Back right after this.
Is your home or condo looking old, worn out, and in need of a fresh look? Then you need PD Painting to paint your property and make it look like new again. PD Painting will first properly prepare your home and condo and then use only the highest quality paint products. After many years in the painting industry, PD Painting has achieved a reputation for always delivering a reliable and professional finish. PD Painting is fully licensed and insured and offers a 7 to 10-year warranty. Their technicians are expert craftsmen. Let PD Painting handle all the details and then sit back and watch them restore your property and bring back that brand new look and feel. Need a service call? PD Painting will be there on the spot. Need financing? PD Painting can offer that too. Call PD Painting at 888-416-3204. Again, that's 888-416-3204. Go to the website pdpaintinginc.com. Need painting done in your home and community? Contact the experts at PD Painting.
This message is for anyone who has taken on the important responsibility of becoming an officer or director in a homeowner or condominium association. It is also for the management companies who work closely with these caring people to make sure things are done the right way. Hello, I'm Gil Pomar, South Florida Regional President for Center State Bank, now the second largest bank based in Florida. Our bank, Center State Bank, has an amazing team of professionals who are exclusively dedicated to the homeowner and condo association market. Your job is not easy. There are repairs and new projects that need financing. There are legal and social issues that need to be understood. There are also technology and servicing issues that your residents want to be improved. Why not choose a bank that knows this business backward and forward? Why not have a local banker who will meet with you face-to-face whenever it is convenient for you or your board? Center State Bank has over 2,000 associations as customers for a reason. Please give us a chance to earn your business. Call Terry Russo at 954-633-1666 to make it happen. Center State Bank is an equal housing lender and a member of the FDIC.
Need an insurance evaluation, audit, or quotation for your condo association or homeowners association? If so, then you need to speak with our insurance experts at Mack Waltz. We insure over 800 associations, and we are the clear leader in this marketplace. Mack Waltz has been in business since 1989. We write insurance on billions of dollars of property values. We are an independent insurance agency representing insurance companies which specialize in condo and HOA insurance. The staff at Mack Waltz works closely with board members and property managers and regularly attends association meetings to help educate the association about their insurance policies. To learn more about how Mack Waltz can save you money and improve your insurance program, call now 954-640-6225 and ask for Greg Waltz. 954-640-6225. Mack Waltz Insurance Group. Let us protect your association.
Back to the final segment of Condo Craze and HOAs here on our YouTube channel. Karen Curtis, attorney Eric Glazer, board certified in community association law. He is basically the guy that invented these classes that will become law because it's on the governor's desk.
As a matter of fact, here's a question from Donna. Donna writes in, what happens if the board doesn't take the new mandatory classes? Now, here's what's great about the new law. You ready? The new law used to allow those directors to just, okay, sign, now I'm certified.
Right.
Remember how stupid that was? How insulting that was to the people that took the classes? Well, now you can't do that.
You have to do both.
Now you're off the board. As you know, if you don't do both, right, exactly. If you don't do both, you're gone. Now the people that are directors right now, they'll have until, I think, June of next year, about a year, to take the 4-hour class that's going to show everything. But after that, right, like a year from now, you're going to have 90 days to take that class. And if you don't do it, you can't sign the stupid form anymore. You're off the board. So the answer to your question, Donna, is you're gone. You're off the board. Isn't that great to say?
I love it. Good for you.
You can't sign that form. So that's wonderful. Let's see. Albie is writing in, we need your class in North Miami Beach and Aventura. I promise we will be there because you're not the first person to ask. Okay, back to the phones.
All right, let's go to John.
Good morning, John. Where are you calling from?
Satellite Beach, Florida. Thank you for your show. It's
Thank
great.
you so much. We are all over the map today, really all over the state.
Ohio.
Yep, and Ohio, correct. How can we help, Lewis? Oh, not Lewis. What's the gentleman's name?
John.
I received a cease and desist letter on harassment from our law firm representing our HOA due to incidents I had with the maintenance man.
Right.
And I only received that after he threatened me physically and I called the police.
Right.
Okay. My question is, I've been in good standing for 15 years there at the HOA. We're condominium association now.
Right.
Now, does the law firm I represent our condominium association also have to represent me?
No,
if
they
I
don't.
Respond to this letter?
You know, I get asked that type of a question all the time. The association attorney, you don't represent those couple of people on the board. You represent me too. You can't come after me,
That's a good
Eric,
question.
right?
Right.
Yeah, I can come after you, okay? So how does it work in a condo association? Let's say there's 200 units, and then you elect a board of directors. Those 3, 5, 7, or 9 people that you elect to the board of directors, the bottom line is you chose those people to represent all of you.
Okay.
And if those 3, 5, 7, or 9 think that you did something wrong, they have the right to direct that attorney to say, okay, write that guy a letter telling him he did something wrong.
Yeah, well, you threatened the maintenance guy, or the maintenance guy threatened
Well,
you?
that's going to be where the fault is, right? You know, who has the fault there?
Okay.
He says he, you know, it's, you know, I say I didn't. He says I did.
He said,
so
she
yeah, he said she said. So we don't know. Without any witnesses there, it's going to be impossible to know, right? Actually, what happened. But he's upset. He's pissed off that he got a letter from the attorney with the attorney not being there, right? So look, if you want, can you write back something to the association saying, hey, shouldn't have written me that letter because you weren't there. You only heard one side of the story.
Right.
The only thing you've heard is from the maintenance man.
And he had a chainsaw.
Yeah, I mean, how about asking me first? You know, what really happened, and I would have told you. So you may want to document on record, and I think I would do that, that the way you wrote me the letter is wrong. It's incorrect. Here's what really happened. Next time, you may want to check it out with me first before writing me a letter. So, you know, I can
Okay,
understand why you're
and-
upset. Okay?
Okay, and they sent my father a letter who owns the condo, not me. His name is only on the deed.
Okay.
Threatening my father that if this behavior continues, they'd go after him.
I understand
he's
because it's his
responsible
unit.
to me. Is that true?
Yeah, I get it. They can sue potentially both of you. That's correct. So, again, try to make it right with the association. Tell them your side of the story and that the last thing you want to do is argue and fight with them. Fair enough?
Yeah, if the police weren't called, it's-
Thanks for the call. One little back to the board question. Lewis writes in, I want to know if we need handicap parking spots on our condo that is only for owners or tenants. We have 180 units and only 223 parking spots,
answer it?
18 of which are handicapped. The bottom line is in a residential community, that's right, you don't need to provide any handicap spots at all. So, you know, according to the Florida Building Code, now maybe in your particular municipality, it may be required, but I can tell you down here, South Florida, unless you have commercial
Right,
stores
like the Grand.
built within, like the Grand, unless you have commercial stores built within your condominium, no, you do not have to have handicap spots. How about we take one more before we call it a day, Rob?
All right, one more. Let's go to James.
How are you, James?
Hey, thank you for taking my call.
No problem. Where
A
you
couple of
calling
weeks
from?
ago, you mentioned something
James,
about the Kaufman language.
Hold on, James. You want to go where you're calling from?
Hey, I'm calling from Tampa.
Tampa. Okay, great. How can we help?
Hey, a couple of weeks ago, you mentioned that if the HOA docs do not have Kaufman, that they don't have to follow the new driveway rules.
Oh, boy. Okay, so Kaufman language, and again, to remind
gonna be
everybody what
tough.
Kaufman language is, Kaufman language would be language in your governing documents that say we automatically adopt the new condo laws or we automatically adopt the new HOA laws when they get passed.
from time to time.
Okay, there are the amendments from time to time, right, as amended from time to time. So, great question. Well, what about all these new laws? Suppose we don't have Kaufman language. Suppose we don't have as amended from time to time language in our governing documents. Do these new laws apply? Okay, so here's the only way you can answer that question. You got to take each new law separately, right? And you got to do an analysis, and it ain't easy. You got to have your declaration next to you, right? And you have to take this new law and say, okay, here's the new law. Does it take away anybody's rights that are in this contract? Does it add new responsibilities to people in this contract that are part of this contract?
Wow.
Does it add additional financial penalties to the people in this part of this contract? And if the answer is yes, and you don't have as amended from time to time language, guess what? That new law probably doesn't apply in your community.
But wouldn't safety usurp Kaufman?
Not necessarily. Not necessarily. It would depend. Okay.
Seems like that would be more important.
Right. And look, this is what I argued
That's
to the
why they
Florida
passed
Supreme
these, is
Court.
for safety.
I hear you.
And it's going to cost them money, so they're not going to apply.
When you say for safety, it could also mean we want the condo or HOA to spend more money for safety, right?
Right.
Okay. Now, if it's causing the condominium or HOA to spend more money, that is not required by the original documents, there's a good argument that says, wait a minute.
I think the safety should overrule it. Maybe you can talk to the legislature about that.
Do you think this insanity should go back to the Supreme Court?
Yes.
And the Supreme Court should re-look at this matter again and say, wait a minute, that's insane that you can have 10 condos, 10 HOAs on one block.
All different.
Each governed by a different set of laws, depending what year they became into existence, who has the Kaufman language, who doesn't. It's insane.
Good thing you're an attorney.
Right. Good. But listen, I hope some of the people at home are attorneys because it's very complicated stuff. The questions are great, but some of these new laws, you have to, again, take an analysis, have your docs next to you, take a look at the law and say, does this change the rights and responsibilities of the people that are parties to this contract, meaning the owners and the association? If it adds on a whole lot of responsibilities, adds on new penalties, things of that nature, very good possibility that that law does not apply.
Even if it makes it safe.
For example, You don't have the right to fine people in your governing documents, right? And you don't have the as amended from time to time language. New law says it doesn't matter if you have the language or not. Yeah, yes, it does.
Oh, God.
Yes, it does.
The law says it doesn't matter, and it still does.
New law says
it's
even
still-
if it's not in your docs. Well, that subjects the owners to new penalties that they didn't sign up for.
Okay.
Right? And if it doesn't have the as amended from time to time language, it doesn't
So
apply
this
in your
is-
community.
It's basic contract law.
Basic contract law. Very good, Professor. Absolutely. That brings us to the end of another show. Okay, great show today. I think
Smart audience.
I think we taught our viewers a lot today. Look at how many laws we spoke about just in the beginning of the show.
And
So-
about trees and plants.
Exactly. Trees and plants, right. We were arborists today as well. Guys, what can I say? Thank you for shattering the record and for tuning in with us today. If you need legal help off the air, you want to give our law firm a call, that's Glazer and Sachs. Give us a call at 954-983-1112. Again, 954-983-1112. Remember, next week, big week, you'll see my interview of Representative Vicky Lopez, who drafted these new laws that came into existence. Okay, so you'll have to tune in next Sunday. In the interim, have a wonderful, healthy, safe week, you and your families. Be well.
Thanks, Eric.